opening credits, the Anti-Deficiency Act. What you need to know.
If you work or have worked in a budget office, you at one time or another have probably heard of the Anti-Deficiency Act. This video attempts to cover things about the Anti-Deficiency Act that you need to know. Here's the plan for the video. First, we'll talk a little bit about what the term anti-deficiency means. Then, we'll talk about the Anti-Deficiency Act itself, what it is, and why it exists. Then, we'll discuss other laws you should be aware of that relate to the Anti-Deficiency Act. Finally, we'll wrap up with tips on avoiding a violation of the Anti-Deficiency Act. So, what does anti-deficiency mean? If we look in a dictionary, we find the definition of anti is opposed to or against. And a definition of deficiency is a lack or shortage. Since our topic relates to money, in this context, anti-deficiency refers to being against a lack of or shortage of money, or, put another way, preventing an organization from running out of money. But what is the Anti-Deficiency Act? Well, first of all, it's not a single act. It's a body of law. It was originally enacted July 12th, 1870. And amended in 1905, 1906, 1950, 1956, 1957, and 1990. Before we get into the details, though, let's first talk a bit about why we have an Anti-Deficiency Act. In order to do that, we need to start at the beginning. It all starts, of course, with the Constitution. Article 1, Section 9, Clause 7, gives Congress the power of the purse by stating that no money shall be drawn from the Treasury, but in consequence of appropriations made by law. Because spending money requires an appropriation made by law, Congress gets to make the spending decisions. But the Constitution didn't come with a set of how-to instructions on how to implement this appropriation power. So Congress has had to establish certain rules concerning this, especially related to time, purpose, amount, and preventing deficiencies. These rules have been established by passing laws, commonly referred to as permanent funding statutes. Interestingly, but not surprisingly, these laws were usually passed to curb perceived abuses by the executive branch. In fact, it's no exaggeration to say that much of federal fiscal law has arisen from the natural antithesis of the executive need for flexibility and the congressional need for control. For example, for 80 years, the executive branch habitually obligated funds in excess of appropriations. This, of course, irritated the legislative branch. But in 1870, there was a tipping point. During the term of Ulysses Grant, the Navy Department obligated funds that were more than double available resources, then asked Congress to appropriate the extra money. Congress felt that they were being coerced into appropriating the funds. So these actions have come to be known as coercive deficiencies. So it should come as no surprise that the laws passed to prevent them came to be called anti-deficiency statutes. In response to the Navy's actions, Senator John Sherman, brother of General William Tecumseh Sherman and later author of the Sherman Antitrust Act, proposed the language that Congress passed as the original Anti-Deficiency Act. Here is the language of the original act. Congress is telling the executive branch two things. They cannot exceed their appropriation, and they cannot spend money in advance of an appropriation. These are the two core elements of the original Anti-Deficiency Act, and they have not changed very much. In the 1880s, during the term of Chester Arthur, executive agencies developed the bad habit of asking employees to volunteer to work overtime, even though there was insufficient funding to pay them. The idea was to create a deficiency that Congress would feel compelled to fund, yet another coercive deficiency. But, as you might guess, Congress wasn't very happy about this. So in 1884, they prohibited this so-called voluntary service. Hereafter, no department or officer of the United States shall accept voluntary service for the government in excess of that authorized by law, except in cases of sudden emergency involving the loss of human life or the destruction of property. This prohibition on voluntary service is the genesis of the issues that arise when the government shuts down. Note also the use of the term hereafter in the legislation. Hereafter means that the prohibition continues into the future, even if the language originally appeared in an annual appropriation act. Keep this term in mind, as I will return to it a bit later. During the term of Teddy Roosevelt, Congress thought that this prohibition was important enough to add it to the Anti-Deficiency Act in 1905.
The language used at that time repeated the original 1870 language and added the amended language concerning voluntary service.
And note this section number, 3679. For many years thereafter, an Anti-Deficiency Act violation was identified as a violation of Section 3679 of the revised statutes. In 1926, the revised statutes became what we now know as the U.S. Code. But let's not get ahead of ourselves. Unfortunately, passage of the Anti-Deficiency Act in 1870 did not stop all of the coercive deficiencies. In 1879, the Post Office entered into contracts that would have exhausted appropriations by April. In response to accusations of violating the Anti-Deficiency Act, the Postmaster General, David M. Key, replied that he could cancel all the contracts and the mail delivery would just have to stop. Again, Congress was not pleased, but they felt coerced into appropriating the money. So, in 1905, they amended the Anti-Deficiency Act and added the apportionment process. This is the language from 1905. Note the purpose is to prevent undue expenditures that may require deficiency or additional appropriations. Preventing deficiencies is, of course, what the Anti-Deficiency Act is all about. But Congress had another trick up its sleeve. In the same amendments, they added civil and criminal penalties. Even though the act had been around since 1870, there were no penalties for violating it until 1905. Then, you could be removed from office, fined a minimum of $100, or imprisoned for at least 1 month. But back to the apportionment. There was just one problem. In 1905, there was no Office of Management and Budget, so federal agencies approved their own apportionments. In addition, the head of the agency could even waive the process altogether. And of course, they did. Permitting the waiver process allowed just as many deficiencies as before. So, Whenever Congress is unhappy with an outcome, what do? They pass another law. In this case, they again amended the Anti-Deficiency Act in 1906, basically disallowing apportionment waivers except in emergencies and requiring the departments to notify them of such waivers with the reasons. The story now moves to 1921 with the passage of the Budget and Accounting Act during the Warren G. Harding administration. This act, among other things, like creating a budget process, created the Bureau of the Budget in the Treasury Department. Interestingly, Congress did not give the Bureau of the Budget the apportionment responsibility. It stayed with the agencies. The first director, a man by the name of Charles Dawes, requested notification of apportionments and waivers, but otherwise the Bureau of the Budget had little power over apportionments. In 1933, Franklin Roosevelt began to see the power of the apportionment process. So he signed Executive Order 6166, giving the Bureau of the Budget the functions of making, waiving, and modifying apportionments of appropriations. In 1939, FDR, using the new Reorganization Act of 1939 and Executive Order 8248, moved the Bureau of the Budget to the newly created Executive Office of the President. One of the purposes in his executive order was to supervise and control the administration of the budget. FDR was the first president to recognize and use the apportionment power. The next event that affected the Anti-Deficiency Act occurred in 1947 with yet another post office coercive deficiency. The post office had only 1% of its annual funding allotted for the fourth quarter. This time, Congress reacted by amending the Anti-Deficiency Act in 1950 during Harry Truman's term to give the Bureau of the Budget statutory authority over apportionments, and by making exceeding an apportionment a violation of the Anti-Deficiency Act. In addition, the law stipulates that exceeding an amount permitted by regulations, something we call an allotment, would also be a violation. To add more teeth to the punishment, Congress increased the criminal penalties to a maximum $5,000 fine or a maximum of 2 years in prison, or both. And finally, Congress passed legislation in 1950 that required agencies to have systems of administrative control that would restrict obligations to amounts apportioned and enable agency heads to fix responsibility for exceeding an apportionment. Except for 3 minor amendments that occurred in 1956, 1957, and 1990 that I'll get to shortly, the Anti-Deficiency Act, as we know it today, was pretty much in place by 1950. So, to reiterate, we can see that the Anti-Deficiency Act is not one single piece of legislation. Rather, it's a collection of legislation that started in 1870 and has continued into the present day. Handily, for us, in 1982, Congress actually took all of this body of law, revised it, codified it, and enacted it into positive law in Title 31 of the United States Code in a section called Money and Finance. Now we have a place where we can actually find something called the Anti-Deficiency Act. By codifying all the relevant legislation and enacting it into positive law, Congress makes that law the legal evidence of the laws therein contained. Let's go over the relevant sections of the Anti-Deficiency Act in Title 31 as they exist today.
Title 31, entitled Money and Finance in the United States Code, is made up of 6 subtitles. The Anti-Deficiency Act is found in Subtitle 2, the Budget Process, in Chapters 13, Appropriations, and 15, Appropriation Accounting.
In Chapter 13, the relevant Anti-Deficiency Act passages can be found in Subchapter 3, Limitations, Exceptions, and Penalties. Section 1341 is the limitation on expending and obligating amounts. These two limitations on making or authorizing an expenditure or obligation exceeding an amount available in an appropriation and involving the government in a contract for the payment of money before an appropriation is made are the two core prohibitions we first encountered in 1870. In 1990, in conformance with the Balanced Budget and Emergency Deficit Control Act, the Anti-Deficiency Act was further amended, adding prohibitions on making or authorizing an expenditure or obligation of funds required to be sequestered, and involving the government in a contract for the payment of money required to be sequestered. Section 1342 is the limitation on voluntary services. This limitation was first passed in 1884 and was added to the Anti-Deficiency Act by amendment in 1905. The 1990 amendment included the addition of language stipulating that emergencies involving the safety of human life or the protection of property does not include ongoing, regular functions of government, the suspension of which would not imminently threaten the safety of human life or the protection of property. This amendment was added to clarify who could work during a shutdown of the government. Section 1349 covers the adverse personnel actions that apply to the unintentional violation of Section 1341 or 1342 of the Anti-Deficiency Act, namely appropriate discipline including suspension from duty without pay or removal from office. Section 1350 covers the criminal penalties for a deliberate violation of Section 1341 or 1342, a $5,000 fine and 2 years in prison or both. Section 1351 covers reports on violations. One of the uglier requirements of the Anti-Deficiency Act is the reporting requirement. A letter to the President, the Speaker of the House, the President of the Senate, and the Comptroller General, who then publishes the relevant information online. Such reports have to give the date, amount, and account involved in the violation, the position of the person responsible, the discipline imposed, a statement about the adequacy of the administrative control system, and a statement of actions taken to prevent it ever happening again. In Chapter 15, we're focused on Subchapter 2, Apportionment, and Sections 1511 through 1519. Section 1511 provides a few definitions. Section 1512 covers the requirement to apportion funds, either by time or project or a combination. It also covers reserves, something that has kind of fallen out of favor. Section 1513 covers due dates for submission of apportionments and the timing for approval. Note also that this section identifies the President as the apportioning official. Of course, this authority is delegated to OMB. Section 1514 establishes the requirement of a system of administrative control that has to be prescribed by regulation. This system has to restrict obligations to amounts apportioned and enable the head of the agency to fix responsibility for over-obligations. A 1956 amendment was made in response to a proliferation of Anti-Deficiency Act violations. This amendment suggested financing operating units at the highest practical level, from not more than one administrative division for each appropriation affecting the unit. Section 1515 establishes the requirements for submitting apportionments that necessitate a deficiency or supplemental appropriation. This process is rarely used anymore. In 1957, this provision was amended to require the head of an agency to certify the need for a supplemental. Section 1516 identifies exemptions to the apportionment requirement. Very few HHS apportionments are exempted. Section 1517 is very important. This is the section that makes exceeding an apportionment or an amount permitted by agency regulations required by Section 1514 a violation of the Anti-Deficiency Act. In HHS, the amount permitted by agency regulation is what we call the allotment. Section 1518 is identical to Section 1349 concerning adverse personnel actions that can be taken if a violation occurs. And Section 1519 is identical to Section 1350 concerning the criminal penalties that apply if a violation occurs. Section 1517B requires reports of violations of Section 1517, just as Section 1350 did for violations of Sections 1341 and 1342. So, let's map this out. Sections 1341 and 1342 and 1517A are the three sections that are the core of the Anti-Deficiency Act. Violations of these three sections are subject to the penalties in Sections 1349 and 1350, 1518 and 1519, as well as the reporting requirements of Section 1351 and 1517B. The remaining sections apply to the apportionment process: what has to be apportioned, who does it, when, and what systems are required to control amounts apportioned. So, this is a concise map of the sections of the Anti-Deficiency Act in Title 31. Let's review the violations. You violate the Anti-Deficiency Act when you obligate or expend funds in excess of an appropriation, before an appropriation is made, in excess of an apportionment, excess of an allotment, or if you accept voluntary services without proper authority. Historically, since violations have had to be reported to GAO, about 52% have been appropriation amount violations. 11% have been forward funding violations. 31% have been apportionment violations. 7% have been allotment violations, and 5% have been voluntary service violations. If you're wondering why these don't add to 100%, it's because many reports had multiple violations. But there are 5 other related statutes, also located in Title 31, which, though lack of compliance in itself is not punishable as a violation of the Anti-Deficiency Act, non-compliance of any of these statutes could cause a violation of one of the core provisions. Before we get to them, let's do a quick review of Appropriation Law. The Anti-Deficiency Act illustrates a part of what is referred to as Appropriation Law. Appropriation Law is based on the concept that the proper obligation of federal funds has to meet 3 basic conditions. The obligation has to be for a purpose, the amount, and within the time period, called the period of availability, that Congress established in the appropriation of the funds. This intersection constitutes a valid obligation. So far, our discussion of the Anti-Deficiency Act is primarily focused on amount. Let's talk about 5 other Title 31 statutes that, when not followed, could lead to an Anti-Deficiency Act violation. First, the Purpose Statute. In 1809, at the very end of Thomas Jefferson's term, and in response to actions of the executive branch in reallocating appropriations to purposes other than those authorized by Congress, the Congress passed what has come to be known as the Purpose Statute. Basically, this statute states that appropriations can only be used for the purposes stated in the Appropriation Act and no other. This statute is still in effect.
The current version, codified in Section 1301 of Title 31, has essentially the same language.
So how could violating this statute lead to an Anti-Deficiency Act violation? Well, if funds are obligated for a purpose that is not authorized by Congress, like, say, meals and refreshments, for example, then that obligation is not valid, and we call this a purpose violation. If it's an invalid obligation, there are no appropriations available to cover it. This means that any obligation would be a violation of Section 1341A(1)(a), obligating funds in excess of an appropriation. Here's an example of such a violation. Note that funds were obligated from an appropriation for meals and light refreshments at conferences. Since no appropriation was available for these purposes, there was a violation of the Anti-Deficiency Act. Here's another example. In this case, the obligations weren't prohibited, but they were obligated from the wrong account. When discovered, the correction caused the correct account to be over-obligated. So, you can see how important it is to pay attention to purpose. Approximately 40% of violations reported to GAO have been caused by a Purpose Act violation. The second statute we need to look at is the Bona Fide Needs Statute. At the same time as the original Anti-Deficiency Act in 1870, this language was enacted in response to the improper use by the executive branch of unexpended balances which had accumulated during the Civil War. Congress wanted to ensure that appropriations were applied only for genuine needs of the fiscal year for which the appropriation was made. The term bona fide or bona fide means genuine or real. Here you can see the current codified version in Section 1502 of Title 31. Again, violations of the Bona Fide Needs Statute aren't automatically a violation of the Anti-Deficiency Act. But if you charge the wrong year, and then have sufficient resources to cover the obligations in the correct year, you could have a violation. In this example, DoD transferred funds to Interior's GovWorks program, and unused funds were not returned to DoD. Instead, they were used for needs in subsequent fiscal years. This violated the bona fide needs rule and resulted in a violation of 1341A1A. In this example, unobligated funds provided to NIH for IT services were not returned, but were used for new obligations in later years, thereby violating the bona fide needs rule. In this case, they're in violation of 1517A2. So, you can see how important it is to pay attention to the bona fide needs statute. Approximately 12% of reported violations to GAO have been caused by the Bona Fide Needs Act violation. The third statute we need to look at is the Accounting Requirement Statute. This statute was passed in 1950 to ensure federal agencies had accounting systems in place that would provide proper control over spending and could integrate with the banking system, the U.S. Treasury. The 1950 statute is codified here in Section 3512 of Title 31. Note the requirement that agency heads establish and maintain systems of accounting and internal controls that provide, among other things, reliable accounting results that will be the basis for controlling and carrying out the agency budget. And what can happen if you don't have such systems in place? In this example, the Navy was unable to properly exercise internal control and couldn't accurately assess an over-obligation. So they had to report a violation of 31 U.S.C. 1341A1A. In this example, obligations exceeded the apportionment due to a lack of fund controls in place. And here, payroll expenses caused an over-obligation because there were no controls in place while implementing a new accounting system. Roughly 2% of violations reported to GAO were due to a lack of system controls. The fourth statute I want to mention is the Recording Statute. This was passed in 1954 during the term of Dwight Eisenhower in response to the lack of a standard definition of obligation. Without this standard definition, it was extremely difficult for Congress to accurately determine agency needs. In this statute, Congress lists the conditions that have to be met that require the recording of an obligation: a binding agreement, like a contract, a valid loan agreement, orders issued as required by law, grant or subsidy, liability from litigation, employment or services of persons, and any other legal liability.
The current codification of this language in Section 1501 of Title 31 is essentially unchanged.
You can probably guess what might happen if you don't follow the requirements of the reporting statute. In this example, the Army Reserve Command did not follow the requirements of the reporting statute and thereby caused a violation of 1341A. In this example, an allotment violation occurred because obligations were not recorded timely. About 5% of violations reported to GAO have been caused by a violation of the recording statute. Finally, the fifth statute relating to the Anti-Deficiency Act is the Miscellaneous Receipts Statute. This statute was originally passed in 1849 at the end of James K. Polk's term, requiring funds to be deposited in the Treasury without deduction. It's been codified in Section 3302 of Title 31. This statute is most frequently cited in discussions of improper augmentation of an account. That is, adding to or augmenting an account with funds that have not been properly deposited in the Treasury and then subsequently appropriated by the Congress. Let's see how this behavior might result in an Anti-Deficiency Act violation. Here we see that funds were collected from various private entities that should have been deposited in the Miscellaneous Receipts account of Treasury. By spending these funds, the Naval Oceanographic Office violated their allotment, a 1517A2 violation. A similar example, the Naval Observatory violated their apportionment by keeping funds collected for astronomical data that should have been deposited in the Treasury. Improper augmentation violations account for about 3% of the Anti-Deficiency Act violations reported to GAO. Okay, let's summarize. In order to be a violation of the Anti-Deficiency Act, one has to violate one of the core provisions: obligate or expend in excess of an appropriation before an appropriation is made, Section 1341. Obligate or expend in excess of an apportionment or an allotment, Section 1517. Or accept voluntary service without proper authority, Section 1342. But we have also learned that failing to follow the requirements of the Purpose Statute, Section 1301, the Bona Fide Needs Statute, Section 1502, the Recording Statute, Section 1501, the Accounting Requirement Statute, Section 3512, or the Miscellaneous Receipts Statute, Section 3302, could lead to a core violation. Clearly, knowledge of the Anti-Deficiency Act is an important factor in avoiding Anti-Deficiency Act violations. So what are things that we should be aware of to avoid these violations? You need to know the basic rules: how to use your accounting system, special concerns with contracting. You need to know your programs, how to read appropriation language carefully, and you need to know what some typical problem areas are. Concerning the basic rules, broadly speaking, the first step to avoid an Anti-Deficiency Act violation is to know the rules. You need to understand the principles of appropriations law. If you haven't taken a class yet, sign up for one. If it's been a while since you've had a class, sign up for a refresher. Familiarize yourself with the requirements of the Anti-Deficiency Act and related statutes. You're doing this now by watching this video. Know the requirements of OMB Circular A11 regarding apportionments and fund control. All organizations are required to have a system of administrative control. You need to know and understand the accounting requirements of your organization. Now, we know the Anti-Deficiency Act requires a system of control and requires us to use it. So what are some tips on doing this?
Suppose your initial apportionment has amounts apportioned in each of 4 quarters.
You need to understand how your accounting system works regarding current and subsequent quarters in order to make sure that the amounts apportioned in Category A for the second, third, and fourth quarters are not available for obligation in the first quarter. Because an obligation exceeding any of these Category B items would result in a violation of Section 1517, you need to use your accounting system to establish a control on each. This is done by issuing a minimum of one allotment for each category.
What if you have a footnote that only allows 1 million out of 51 million to be obligated until an approved plan is submitted? You should use your accounting system to only allot 1 million until the conditions of the footnote have been met. If you don't do this, you might have a violation like the Forest Service had to report to GAO because they obligated $17 million in excess of a $100 million footnote limit on fire suppression funds. If you have funds apportioned in Category C, future fiscal years, be sure these funds are apportioned as a subsequent quarter in your accounting system, or you could have a violation like USAID's when they obligated Category C funds that had not been properly recorded.
In addition to these examples, you should also use your accounting system to observe statutory limits like earmarks or caps. You should not distribute anticipated resources, and you should document properly and keep track of your obligations versus availability. Special concerns with contracting. Those of you involved in contracting need to be especially knowledgeable of the requirements of the Federal Acquisition Regulations, or FAR, and the HHS acquisition regulations as well. In addition, contracting staff need to be able to determine the difference between non-severable and severable contracts in order to properly assess bona fide need. You need to know the statutory exceptions involved in multi-year contracting. And you need to beware of indemnification. If you doubt the wisdom for the knowledge of the FAR, take a look at this report. Note that the Department of Health and Human Services committed 47 Anti-Deficiency Act violations over the period of fiscal year 2002 through fiscal year 2010, primarily because HHS acquisition guidance concerning contract funding methods did not fully align with legal restrictions on the use of appropriated funds. This led to the forward funding of severable services contracts, as well as incremental funding of non-severable services contracts. Indemnification is the guarantee through a contractual agreement to repay another party for loss or damage that may occur in the future. Since we're forbidden by Section 1341A1B of the Anti-Deficiency Act to spend future appropriations, the act of indemnification can lead to a violation.
Here are extracts of 2 reported violations caused by open-ended indemnification, one from the American Battle Monuments Commission and the other from the National Oceanic and Atmospheric Administration.
Indemnification violations account for about 5% of the Anti-Deficiency Act violations reported to GAO. Know your programs. It's important that you know your programs because roughly 40% of all violations reported to GAO have resulted from purpose violations. It's extremely important that you know what purposes are authorized by your appropriations. For example, are administrative expenses authorized? Are you using the appropriate obligating vehicle? For example, grant versus a contract? Are you charging expenses to the right account? Are you knowledgeable of reprogramming rules and notification requirements?
Here, for example, is a report on a Secret Service violation caused by missing a reprogramming notification.
Because a general provision required a timely notification of any reprogramming in excess of $5 million, a violation occurred. read appropriation language carefully. Many violations occur because of appropriation language changes, so it's really important to read your appropriation language carefully. Make sure your appropriation language hasn't changed in any significant way from the previous year. Check for any new or changes to general provisions, being especially aware of earmarks and ceilings. And keep track of hereafter provisions. In this example, the FY 1993 Appropriation Act capped the pay for certain consultants and scientists appointed for limited periods of time under the authority of the Public Health Service Act. This cap was intended to continue into the future. Note the appropriations in this or any other act or subsequent Department of Labor, Health and Human Services, and Education and Related Agencies Appropriations Act. This prohibition was overlooked, and HHS had to report a violation totaling approximately $125 million, covering all the years they exceeded this cap. In this example, a prohibition on paying the salary for a position requiring Senate advice and consent in an acting or temporary capacity after the second submission of a nomination for that individual to that position had been withdrawn or returned to the President was overlooked, causing these violation reports by the Department of Education and Department of Energy. Note again the language, and for each fiscal year thereafter, applying this general provision to all future appropriations. HHS committed this violation as well, but it was not reported until fiscal year 2017. As you can see, it's really important to carefully read appropriation and general provision language and be especially on the lookout for hereafter language that would continue prohibitions into the future. About 6% of the violations reported to GAO contain an example of exceeding a cap or statutory limitation. Know your typical problem areas. There are certain areas that are ripe for Anti-Deficiency Act violations. One of these is the purchase of prohibited items like food, including water bottles, clothing, gifts, and promotional items. Roughly 9% of violations reported to GAO were concerned with inappropriate purchases, so be very careful about approving purchases of these types of items. Here are some violation reports on improper purchases, like meals and light refreshments, food and flowers, promotional items, clothing, entertainment equipment, bottled water, and so on, and light refreshments. These suggestions are not intended to cover every possibility for violations of the Anti-Deficiency Act. Rather, it's to stimulate thought about the topic. Probably the most important thing to remember is to ask questions. Appropriations law is always evolving, and there are new cases all the time. Keep in mind that while GAO's Principles of Federal Appropriations Law, popularly referred to as the Red Book, contains a lot of useful information in cases, it's continually updated and not always the final word. It's worthwhile to look at opinions from the Office of Legal Counsel website at the Department of Justice. And remember, if you're in doubt, consult your Office of General Counsel.
And in closing, thanks for listening. and so long for now.